Thank you for being here for the final day and what we hope will be a very engaging discussion of where we go from here on out. Just think of last October when the term started and we had so many important issues before the justices are headed their way. The power of unions, public sector unions, the reach of abortion rights, the future of affirmative action. Also not quite yet on the agenda, but certainly on the near horizon was the validity of President Barack Obama's executive order deferring the deportation of more than 4 million immigrants. And I think a lot of people who are in this room and who were here at the end of last year and celebrated certain progressive victories thought that conservatives were going to take the reins more and do what the conservative-dominated Supreme Court had been able to do for many decades, seize those issues and take control. February 13th, of course, changed all that. The death of Justice Scalia suddenly meant that we had a 4-4 ideologically divided bench. For the first time in decades, there was not a conservative majority. And given what we know about President Obama's interests and where we might be headed with the election, there's a very real possibility that instead of having a 5-4 court that tips to the right, it will soon tip to the left. And as everyone up here on this panel understands better than most, and many of you understand, this is a historic moment unlike anything we've had since the Richard Nixon era. So to explore themes of conservative versus progressive jurisprudence and to talk about where the court might be headed in terms of personnel, in terms of issues, in terms of advocacy. We have a group of panelists who are known to everyone in this room, but I'll give their titles and their fuller backgrounds are in the program here. To my immediate right, David Strauss, law professor at the University of Chicago. I'm going to go in order of the presentations this afternoon, and then I'll explain a little bit about how our conversation will evolve. Michael McConnell, on my far right, law professor at Stanford, former federal judge. Melissa Murray, law professor and interim dean at the University of California, Berkeley, right between Professors McConnell and Strauss. To my immediate left, Ilia Shapiro, who's a senior fellow in constitutional societies at the Cato Institute. Then Rachel Moran, law professor and former dean of UCLA. And Steve Shapiro, national legal director at ACLU. The way we're going to progress today, and we're hoping to get lots of questions from you at the end, so think ahead, is to first have each of the panelists talk a bit, maybe for like 5 to 6 minutes, about where he or she thinks, what themes immediately come to mind and should be pursued at this very important moment in terms of how the appointment of a new justice or justices will affect constitutional interpretation, key issues such as race, reproductive rights, and economic inequality. We're going to start with just a little bit of an overview from each of them and then have more of a conversation pursuing certain themes, what kinds of how things will change in terms of advocacy, what kinds of cases might be revisited, how quickly that could happen, for example, involving Citizens United or affirmative action decisions, voting rights perhaps. And we'll start right now with David Strauss. First, we obviously could have a liberal-dominated court, the first since the 1970s, and the 4 appointments of Richard Nixon. What do you anticipate?
Well, thanks, Joan, and thanks to all of you, and welcome. As Joan said, I mean, if unless you're as old as I am, and maybe not even then, you have no recollection whatsoever of a progressive court. Richard Nixon ran against the Warren Court in 1968. By 1971, he'd made 4 appointments to the court, and since that time, there has never been a court with a majority of Democratic appointees and never been a court that could really be characterized as progressive. So I was in high school when the last time there was a majority of Democratic appointees on the court. So we're talking about, as Joan said, really a major change in the evolution of the Supreme Court. If in fact there is a a liberal majority after the election, after the inauguration. Now, I think the real risk here for progressives is that should things work out that way, that we'll go into this with a kind of a list of decisions that we want to see overruled, and essentially adopt a kind of reactive posture. They've been in charge for so long, now it's our turn, we want to get our way. I don't think that's the right way to think about this. I think to a large extent the conservative agenda has been reactive in that way, has been reacting to what they saw as the progressive developments in the law, and I don't think we should fall into the same trap. I think instead of that, what we should do, progressives, should we be able to sort of, again, move to a position where the Supreme Court's a progressive institution, what we should do is try to return to what the core and best elements of the progressive tradition in the United States. There is such a tradition, and it has elements that are worth reviving and furthering. And one of them is a true commitment to democracy. I think the civil rights era has, in some ways, kind of given the impression, I think, to a lot of people on both sides, that a liberal Supreme Court means one that engages in a lot of overruling of statutes and a lot of aggressive judicial behavior. I don't think that's the core of the progressive tradition. I think the core of the progressive tradition is we're a democracy. By and large, we should be ruled at the ballot box, and the court should intervene only when there's some reason to think the democratic process hasn't worked the way it should. And I think that should be one core element of a progressive court. A second core element should be a commitment to equality and inclusion. That's obviously central to the progressive tradition. And a third core element is a trust in federal power to look after the most vulnerable in society. That's been, again, the core of the progressive tradition, the best parts of the progressive tradition, starting really with the Civil War, through the progressive era, through the New Deal, through the Great Society, through the Obama administration. And what the court should be in the business of doing is furthering that. One game I like to play with some of my conservative friends when they announce that, sure, the conservatives are being active, and as the conservative court is activist in, say, the healthcare litigation and Citizens United and Shelby County, striking down acts of Congress. But when you liberals had control of the court, you struck down acts of Congress too. And I say to them, okay, name me one act of Congress that the Warren court struck down. Just one. Name one. Name one. There are a couple, but I bet you never heard of them. And that's because the Warren court had the position, adopted the position that their job was to get out of the way if the democratic process is working. And some of the most important Warren court decisions, some of the ones that have been most vigorously attacked by conservatives, were ones that empowered Congress. And I think it's important that we return to that legacy. Okay, enough abstractions. Here are some concrete predictions for you. Prediction number one. Originalism as a way of approaching constitutional interpretation on the Supreme Court will disappear from the scene. Now I should say that, just as sometimes terrible wars have spin-offs, technological spin-offs that are actually quite valuable for humanity, so the intellectual catastrophe that has been originalism on the Supreme Court has had some very valuable spin-offs in intellectual history and work done by scholars on the intellectual foundations of the Republic. Much of that, I have to say, done by my friend and colleague Michael McConnell, 2 seats to my right, and people who've worked with him, and that's been impressive and valuable work. But as a way of actually dealing with constitutional issues today, where did anyone get the idea that we can resolve these difficult, complex issues so rooted in modern times by taking our orders from guys who lived, and they were guys who lived in the 18th and 19th centuries? I don't know who had that idea. It's obviously not a good idea, and it's going to disappear. Okay, that's prediction number one. Prediction number two, affirmative action and gun rights will cease being difficult issues. The court will recede. No decisions need to be overruled. There's enough leeway in the cases for the court to give way to the democratic process and resolve those issues according to politics, which is how they should be resolved. Prediction number three, voting rights will be extremely important. This will be an area where I think you will see the courts acting fairly aggressively to ensure, again, that the democratic process actually works. There are changes taking place in society, and it's important that our democracy recognize and reflect those changes. And we're already seeing at the state level some efforts to defeat that, and I think that is an area where you'll see the courts acting fairly aggressively. So those are my 3 predictions, as well as my more abstract counsel.
Thank you, David. Michael McConnell, you want to counter that, add some of your thoughts? And what do you anticipate if the court does pick up a 5th or 6th liberal member? And what fractures might appear among those on the left, as we've seen among those on the right?
Well, this was actually the main thing I was going to comment on, is that the left of center justices have been extraordinarily cohesive in recent years. And I think that there may be, and I think it's easier to be cohesive when you see yourself as in a dissent than when you see yourself in the majority. And my only prediction is that it isn't likely to stay that way. For example, when all 9 justices were Democratic appointees by the time of FDR and Harry Truman's, by the time of those presidencies, every justice appointed with a certain common theme of upholding New Deal legislation. You might think that that would mean that the court would be a working, 9-justice coherent majority. In fact, the fracturing began extremely early. You had people like Felix Frankfurter, who were deferential to the political process. David Strauss represents the Felix Frankfurter idea, but then you also had William Douglas, who was a much more radical justice. We're going to have those 2. You had Hugo Black, who revered those late 18th century framers that David thinks we should pay no attention to. About the only thing I really disagree with David about is if he thinks that attention to text and history are going away, I think he's really quite wrong. It will take different forms, of course, but the reason we pay attention to this is that what we're doing is constitutional interpretation. What does that mean? It means we're interpreting a constitution. When you're interpreting a document, of course, you must pay attention. You may not stop with the history of when it's written, but of course, what those words mean and what they were understood to mean is going to be your beginning point. And people can rail as much as they want against isms like originalism, but reading documents there's a certain logic to that. So in any event, they're going to be, I think we can look forward to seeing some serious differences, both methodological and substantive, as we move forward. Just as the conservative justices of late, there were some pretty serious originalists and some pretty serious criticisms of originalism among the 4.5 conservatives on the court. It'll be interesting to see. There's been this slogan of sort of living constitutionalism, but at least looking at it from the outside, it looks like a slogan rather than actually a methodology. And the interesting question is going to be, is there any constraint there? The whole purpose of constitutional methodology is to have constraint. And so the question, at least one way to put it, is there anything that 5 justices on the Supreme Court can't do? And if there isn't anything they can't do, then we are unmoored from anything that resembles law. But what are the things that they can't do, and how do we know what they are? And I think that there are going to be quite different answers to that. There are going to be some, like David, who are going to say respect the political process, but there are going to be some who say this is our chance to leapfrog the political process and do things that we aren't likely to be able to get through the Congress. And that's going to be especially true as I'm not a politician, and in this particularly in this weird election year, I've been wrong and wrong and wrong and wrong, so don't expect great predictions from me. But I have this sort of sneaking suspicion that Hillary Clinton is not going to be a very popular president, which probably means that Congress is going to be back in Republican hands pretty soon, and that means that there's going to be gridlock in Washington, and there's going to be a tremendous temptation to do what David is saying progressives should try to resist. That's going to produce fractures. People on the court are going to disagree with that. And then I think one of the really huge fractures on the center, on the left and center left, is going to be about is it going to be a civil libertarian progressivism, or is it going to be a kind of culture warish substantive progressivism? And I particularly think about what's going to happen to, say, freedoms of speech, because there is a civil libertarian tradition which holds that for people to be able to speak is a positive, good thing. It's part of a free society to protect it, even when we disagree with what they have to say. But as we especially see on American campuses today, but also in other walks of life, there's also a major movement on the left that believes that freedom of speech is really only legitimate when it is in service of the voices and power of previously subordinated groups, and that it is a moral imperative to break up the Trump rallies, to demand safe spaces, to shut people up when their voices are not along with the agenda. I think that's going to be a fracture too, and one that that we should be very concerned about it. I'm curious to see what Steve Shapiro thinks about that, since he so much reflects one wing of that division. So I think it'll be anybody who's expecting sort of a simple now we're all together, we're going to accomplish things, unity, I think, I suspect you'll be disappointed.
Thanks, Michael. I think one of the things we'll pick up on after everyone's spoken is the free speech area. But I want to turn to Melissa next, because she's going to speak a little. I think you're interested in the advocacy, and when Michael referred to the 4.5 conservatives, I have a feeling the half was Anthony Kennedy, and for such a long time, advocates have targeted Justice Kennedy as the key person. What do you anticipate? Would Justice Breyer be someone who would be more in folks' sights now? What does it mean for advocacy at the court if things shift to the left?
So let me preface my remarks by making two observations, both drawn from personal experience. I was in high school when Justice Marshall stepped down from the court and Justice Thomas was nominated to fill his seat. And I remember my father saying, "This changes everything. The world has changed." And that was right, I think. I think it really, the nature of the jurisprudence certainly changed. What it meant to have an African American on the court changed a little bit. This last year, when Justice Scalia passed away, it was over President's Day weekend, and my family and I were spending the long weekend in Tahoe, and we were coming back from skiing, and the phone started pinging. And so, we stop, we pull over, we look at our phones, we see Justice Scalia has passed away. My husband starts furiously texting. We're in the parking lot of a Safeway in Truckee, California, and he's texting furiously, and I'm texting furiously. And our 5-year-old son is in the back seat. He's like, "What's going on, guys? Why are we stopped?" And so my husband says, "Everything has changed. The world has changed." So I'm thinking, I've married my father. That's a problem. And then my son in the back seat bursts into tears and says, "I don't want the world to change. I love the world." The story is just, I think, to illustrate the profundity of the moment. I mean, I do think this is a major shift in the composition of the court and its personnel, and as Joan suggests, it means that things will be different in the way issues are framed and presented to the court. And from my own experience in this last term, I wrote an amicus brief in the Hellerstedt case, and I found it to be a very challenging experience. I ordinarily write about reproductive rights and justice issues. I'm very interested in the regulation of the right to abortion throughout the country. And I thought this would be a really great opportunity to take what I write about in my scholarship and actually put it to good use in a practical setting. And I found it to be so challenging to write that brief because I knew that I wasn't writing to a broad audience. I was writing for one person. And that person was Justice Kennedy. And I think it's very challenging, it's very cabining in terms of advocacy to be addressing and framing claims only to speak to a single person and a single voice. So for me, it was a very daunting experience. I did not say everything I wanted to say. I did not leave everything on the dance floor, as the young people say. I held back a lot of things. I wound up relying on decisions of Kennedy that I don't necessarily agree with in all cases, or whose logic I have questions or doubts about, because I was speaking to him, trying to reason with him, trying to get his vote, because his vote is the one that in this case seemed like mattered the most. I think one of the most profound changes we'll see on the court is that I don't think Justice Kennedy is going to be in that position going forward if there is a new liberal justice appointed to the court. If a series of new justices are added, I think the composition and the dynamic between the justices will change, and I think we will see a shift. I don't know if it's to Justice Breyer, and again, shifting to Justice Breyer as sort of the determinative voice would mean a lot of different things in terms of advocacy. I'd probably put more statistics in my briefs, pack it with statistics. But I do think that maybe a shift in composition might mean maybe there isn't a single voice that we're all speaking to, that we might be speaking to more people, and because of that, our conversations might be more nuanced, more complex, maybe more robust in the way we think about things and the way we frame claims. I think Michael is right that the idea of a new liberal court sounds appealing in a lot of ways, but there are different strains of liberalism. I mean, 50 Shades of Gray, 50 Shades of Liberalism. And I don't know that we're going to get the kind of cohesive, progressive court that we might imagine. We might get a progressive court, but in different ways. And I think it's important for us to be realistic about that. I hope that with the addition of new personnel, one thing we might get are more justices who are very keenly attuned to the way that their decisions affect the real lives of people on the ground, because I think even with the liberal wing of the court, there are precious few justices who really understand what it means to have a Fourth Amendment jurisprudence on the ground, what it means in the real lives of people. I hope that changes, and I hope that we do see more justices with that kind of real-world experience that can bring that to the bench. That, of course, as Michael suggests, may raise other questions that may divide us further, but I think it's important to, again, think about those things as we move forward. So I'm excited. The world has changed. Maybe we like the world the way it was. Maybe we're excited for what comes, but I think this is a really profound moment for all of us.
Thanks, Melissa. Thanks especially for touching on some personnel. Let's turn to Ilia and talk about maybe some potential new issues in terms of the sharing economy, technology. What sorts of themes do you think could emerge with a new court and at this time?
Well, first of all, thanks very much for having me. I've actually never spoken at a Federalist Society National Lawyers Convention, so thanks for having me here. I'm also, I think, the only one that has never been a named professor or a dean of any sort, so I guess I'm happy to play my role as a comic relief or your crazy, token crazy libertarian or what have you. Before I answer Joan's question directly, I want to make one note about my former professor David Strauss's comment about the death of originalism. I think it's a little premature. So I don't know if my friends at the Constitutional Accountability Center, anyone is here, but the progressive originalist theme and development of theory, I think, has been very important to the extent that on many, many issues, we're all originalists now. Look at, we're talking about gun rights, look at the Ninth Circuit ruling this week. That was all about history and what did 18th century societies think about concealed carry and things like that. So that's one example of very, very many. So I don't quite think that now it's all just abstract theories of justice divorced from text structure and history. And on a personal note, kind of paralleling Melissa's point, on February 13th, when Justice Scalia died, that was the same weekend that Donald Trump won the New Hampshire primary. So dark, dark days for me. And the next 2 months or so, the only way I got through it was by looking at my newborn son, who's now 5 months. At the time, he was 2 months, smiling face every morning.
Congratulations.
On the one hand, that's how I got through it. On the other hand, I thought, what am I bringing him into? Anyway, new issues, right? Very hard to make predictions, especially about the future, as Yogi Berra said. And I caution you on being overly optimistic or kind of just taking it as assumed that Hillary will be the new president. There's a chance that neither of these least popular major party candidates in history will be their respective parties' nominees in the end. Joe Biden gave a fantastic talk on Thursday. I think it would be missing a great opportunity for a landslide win by not subbing him in rather than Hillary, but nevertheless, we could talk about what Trump's judges might mean. It's more of a wild card. But again, now finally getting to the question that was actually posed. You can never predict what the issues are that are going to arise. You know, we're so comfortable with affirmative action, gun rights, administrative deference of a certain rubric, the war on terror. A president appoints judges that he or she will think will rule in ways favorable to the issues of the day. But it doesn't take very long for completely new, unanticipated things to come along. Look at Fourth Amendment jurisprudence, right? And by the way, there, replacing a Scalia with a so-called moderate progressive like a Garland is a step back for civil libertarians, at least. So I caution you to be kind of more nuanced when you're thinking about what Scalia's removal means or vacancy means. But an issue like Kylo, right? Thermal imaging to sense pot growing. Well, what happens now when we all have in our pockets these devices that do all sorts of things that are more or less in common use? I think rather than continuing to apply these kind of very old doctrines that were set a product of their age, even the reasonable expectation of privacy, right, from the 60s, I think we really need to rethink doctrine to make sure that privacy rights and criminal defendants' rights are protected against new developments in technology, in investigation, in surveillance. And it's not just political matters that we can defer to majority votes. I think these are very serious issues, and who knows how they'll turn. Or the sharing economy, micro-regulation, as some people talk about. Millennials don't think of themselves as big, economic deregulation sort of people until you start talking to them about food trucks and Uber and a whole host of kind of lifestyle regulations that they think, well, that's silly. Why do we have those rules? Why is government in bed with unions to create these sclerotic anti-equality, anti-liberty sort of regimes? Why can't we, at the touch of a button, the technology has developed my freedom to do all these sorts of things, and yet these old fuddy-duddies, whether it's our state capital or in Washington, are preventing that dynamism. So I think we'll have a lot of issues that don't break down on conventional lines, and the briefing will not look like, shall we revive Lochner or not? There will be antitrust issues, there will be administrative law issues, there will be a whole host of ways in which this wolf, as it were, to hearken to Scalia, will come either as a wolf or a sheep, in ways that we can try to brainstorm, but 10 years from now, I guarantee you there are going to be Supreme Court cases that we can't conceive of right now.
Thanks, Ilia. We're going to hold on Rachel for a minute because she's going to address changes in America in the demographics that can overtake even changes at the Supreme Court, and go to Steve Shapiro to talk about, picking up a little bit from Melissa on advocacy. What would your wish list now be as someone who's represented the ACLU during, actually you came on in 1993 onto your own bench of sorts. So you were so familiar with this court and Scalia being part of it. What kinds of things would you like to have happen now without him as the fifth.
Well, as the second Shapiro on the panel, I'm going to follow Ilia and not immediately answer your question. And
Shapiros are good at that.
and just say that I actually do not want to wade into the whole discussion about originalism today, other than to say, as the only New Yorker on the panel, I have come to understand that the answer to every constitutional question, indeed the answer to every question in life, can be found in the musical Hamilton. And if you don't believe me, you should watch the Tony Awards tomorrow night. So, as Melissa said, this is a sort of heady moment, but as for progressives, potentially, right? We have a presidential election still to be fought, and we have a lot of senatorial battles still to be fought, and so I think it's a mistake to presume the outcome of those. I certainly do not. But we are at least facing a realistic possibility, as David said, of having the first progressive court in my entire professional career. And I too was in high school when Richard Nixon began to transform the court in the late 60s and early 70s. And so even though David has said we should not have a wish list, I have to say it's kind of an irresistible impulse. And so I'm going to give you at least my partial wish list. And many of the things that appear on the wish list are really judge-created doctrines. So they do not, in many instances, it's not universally true, call into question the issue of deferring to democratic decision-making, because in many ways, I think what I would like to see overturned are doctrines that the Supreme Court has developed that impede democratic decision making. I also agree with something that Ilia said, and that is that it's a mistake to assume that anything is going to change abruptly. This is not an institution that it changes abruptly. And so part of my answer to Michael's question is, what is it that the Supreme Court cannot do? Is an answer that comes out of methodology. And I think precedent and stare decisis matter to the Supreme Court and to everybody on the Supreme Court, liberal, progressive, moderate, conservative, whatever label you want to attach, in a way that does not matter to politicians engaged in the legislative process. They can come in tomorrow and repeal Obamacare if they have the votes to do it. The Supreme Court is not going to tomorrow overturn one of its decisions abruptly. It's just not the way the institution operates. And so when you think about a wish list, I think one of the things we also have to think about as advocates is a path to that wish list. And the path to the wish list is almost never going to be, let's try to hit a home run our first time at bat. It's going to be an incremental strategy that gets you to a point where the ultimate change you want to achieve feels like a small step to the Supreme Court and not a big step. So what's on my list? Let's start with reproductive rights. One of the cases that we're still waiting to hear about this year is the case that Melissa filed an amicus brief in, Whole Women's Health versus Hellerstedt. We'll see what the Supreme Court has to say. But if I had my druthers, I would like to see the Supreme Court revisit the undue burden standard, which I think has been largely a disaster for women and been doctrinally incoherent in many ways. And I would like to see the Supreme Court recognize that a war on abortion is in fact a war against women, and to do what Justice Ginsburg has been asking us to do for several decades, and that is to place the right to reproductive choice firmly, not only in the sphere of personal autonomy, which is, I think, an important concept, but also recognize it as an important form of sex discrimination. I think that would both... There would be many, many advantages to that, but one advantage is I think it would also clarify the standard of review that applies to the kinds of abortion restrictions that we see in Texas and around the country. On race, I would love to see two things happen. One is, and there was an op-ed piece in the New York Times about this a week or two ago. Many of you probably have read it. I think the Supreme Court took a serious wrong turn when it said that the 14th Amendment and the Equal Protection Clause had nothing to say whatsoever about racially discriminatory impact as opposed to governmental actions that are motivated by discriminatory intent. I think that should be revisited. I would also love to have the Supreme Court recognize in the context of affirmative action that there is in fact a difference between invidious discrimination and discrimination that is designed to help people who have been left behind in many, many ways and suffered. The third thing I'll say, because we're running out of time, has to do with criminal justice. I have said for many years there were two things that I thought would happen during the course of my career. I've gotten one of them, and that was same-sex marriage. I also believe that the Supreme Court will, in my lifetime and not in my career, abolish the death penalty and recognize it. As Justice Marshall used to say, is cruel and unusual in all circumstances. And then finally, I would like to see the Supreme Court put some teeth into proportionality review of criminal sentences. I recognize that criminal sentencing is primarily a legislative task, but I think there are criminal sentences that are so disproportionate that they cross a constitutional threshold. We have seen a little bit of this with juvenile life without parole, but there are many other sentences out there that are hard to justify in any reasonable way, and I think the Supreme Court could take a more active role in pushing the criminal justice reform that is becoming a part of a national discussion. The Supreme Court needs to be part of that discussion as well.
Thanks, Steve. You know, if a guy is going to invoke Hamilton, though, to use the metaphor of a home run rather than not throwing away your shot or being in the room where it happens, really. Okay, now we'll turn to Rachel, who's noted an unprecedented change in demographics and address that in the context of the judiciary in this new era, and then we can segue into meatier discussion.
I have to make a confession. I'm here with a lot of court watchers. I'm a people watcher, we the people watcher, and we truly are undergoing an unprecedented demographic shift. So in 2014, if you looked at Americans under the age of 5, most are now non-white. By 2020, most Americans under the age of 18 will be non-white, and by 2016, whites will be a minority in the total population. We will have a majority of minorities, or what the Census Bureau calls a plurality nation. And this has profound implications for understanding ourselves as we the people. I'm currently working on a project at the American Bar Foundation on the future of Latinos in the United States, law opportunity and mobility. And I really feel this is critical because by 2050, Latinos will represent 30% of the American population, and yet in discussions of law, policy, and the Constitution, they are regularly invisible, and there is very little research out there on these issues affecting the Latino community. So let me begin with some of the issues that I think will be tremendously important as we move forward. One of these is clearly immigration, and many Latinos now occupy a very liminal and uncertain state in American democracy because we have a constantly shifting perception or set of rules and regulations and set of actors who make the decisions respecting their permanency, their livelihood, their security in their homes and their families. This term, for example, United States versus Texas, is addressing the permissibility of the use of executive power to create some categories in which deportation will be deferred and you can gain some degree of security in your presence here in the United States. But when it's up for grabs on a regular basis, that affects your ability to be fully integrated into a population where we know most people will remain. The next critical area is political voice. Now, I think there are a lot of ways that Latinos do not get heard, partly because of issues of citizenship and age, but there was a case just decided this term called Evanwell versus Abbott, coming out of Texas, which proposed to change the rule from one person, one vote, to one voting age eligible citizen, one vote. Now that would have hurt a number of groups, but nobody got hurt more than Latinos, over half of whom would have disappeared from the counting process under the new rule. we would have been in effect disappeared. Now, the court did decide unanimously that no such change was mandatory, but it also left open the possibility that states might consider using this alternative formulation in deciding how to adjust their counting process. And so we'll wait to see whether that comes back. But that is an example for Latinos of wondering about how their voice will be counted, whether they will even be part of the population that is considered for the allocation of government services. The next areas that I think will be critically important relate to growing inequality in the United States, because Latinos are coming into their own as a part of this country at a time when we see levels of inequality unprecedented since the Gilded Age. To give you an example of the condition of Latinos in the United States, there was a study done on the color of wealth in Los Angeles, which is where I'm coming from, and they asked various households how much money they had in the event of an emergency, liquid, to address it. The median amount available in a household headed by a person of Mexican origin was, guess? $0. Zero. The conditions of economic insecurity are profound. Latinos are also, by some measures, the most segregated population in America, isolated by their ethnicity, their national origin, their language, and their poverty in underperforming schools. We continue to lag behind in higher education, and we exist in the shadow of Vischer versus Texas, which will tell us whether the University of Texas can continue to do some very limited forms of affirmative action. And we know that Latinos cannot take their full place in our society without the kind of education and employment opportunities necessary to have some form of security and voice. And therefore, I urge this group to think about the concepts of social citizenship, which Willie Forbath has advanced, which see our dignitary principles as the basis for some forms of entitlement that are constitutionally recognized, so that we do not have permanent underclasses in the United States of America. Now, the final thing that I do want to mention is that the criminal justice system, precisely because of the economic and educational marginalization of blacks and Latinos, remains a significant factor in interrupting and derailing opportunity. And in the next term, there will be a case called Peña Rodriguez versus Colorado. It's not just out on the streets. This is a case involving a jury deliberation where two jurors stayed behind to report that one of the jurors had made comments about men of Mexican origin and their incapacity to control their sexual impulses, and questioned the reliability of a witness based on his allegedly undocumented status, when in fact he was not undocumented. And they felt that this might have tainted the deliberations, and the real question is whether those jury deliberations are sacrosanct, so that a general atmosphere of anti-immigrant, anti-Latino sentiment can enter a jury deliberation with no recourse. Finally, I want to urge that we find ways to incorporate Latinos in this conversation. One of the things we found is at the lower court and in the appellate courts and in the highest court of the land, Latinos are significantly underrepresented because they are such a rarity in the legal profession. And so as a result, Latinos are not at the table in these cases, and we have a couple of organizations that are the usual suspects like MALDEF, Latino Justice, PearlDEF, but they are overwhelmed because as this population grows and the underrepresentation in the profession remains relatively static, the access to justice gap is only growing. So I would call upon all of you, I see many, many youthful faces here. You are the future. This is your future. Embrace it, take it, make it your own. It's not just about what the justices do, it's about what all of us do. Thank you.
Rachel, let me follow up with one question and then have the others jump in on this. And that's, just how much can be done with the judiciary. We're obviously focused on the Supreme Court and this major moment of change with the Supreme Court. But given the kind of agenda you rolled out, how much does the nation also need to count on a new executive, legislative options? And so if you would just briefly address it, and then I know David has some interest in that too.
I want to say that I don't think the courts operate in isolation, and I think creating an institutional dialogue among the different branches of government is critical. But we can't create a dialogue in which one branch becomes a complete roadblock, right, to advances in the other branches. I think, for instance, it's a shame that Congress has been so paralyzed, that we have one branch that's clearly dysfunctional in my view, but we've also had a court that sometimes has, where there's been a rare moment of some evidence of function, cut that off with a very narrow understanding of what is permitted by Congress, based on whether it's necessary and congruent or some other kind of tests that make it very hard to produce the relevant data for Congress to act. It kind of reinforces that paralysis. I also don't want to forget the states, and federalism does promote a certain kind of autonomy and experimentation that is valuable, but in some cases I'm worried that there are abuses going on that are unredressed because we've taken such a narrow kind of approach to anti-discrimination law, for example. So I don't see this as the courts going it alone. In fact, if I thought the courts were going to go it alone, I'd be very afraid. Because I think that we, the people, mobilize through the political process as well. And one of the consequences of these shifts is if the court can create a fair and level playing field for political participation, and we can redress some of the inequities created by allowing big money to dominate when we know it maps onto particular racial and ethnic characteristics, that I think we will have a healthier democracy. We will have a court that allows that democracy to flourish and to reach conclusions that address the new face of America.
David, how do you keep expectations in check for what one branch can do? I mean, this is such a moment, but how quickly can change happen at the Supreme Court, given that cases percolate up from below? We're not sure at all what some of these justices on the left will end up doing in terms of kind of a reaction formation sort of thing that Michael had mentioned.
Yeah, I think that's an important point. It ties in with what Steve said earlier about how the Supreme Court is not an institution that changes direction suddenly for its own reasons, as well as the reasons Joan mentioned about the way the legal process works. And in addition, as Joan's exchange with Rachel suggested, a lot of the decisions on, that a lot of us want to say are wrong and would wish had come out the other way, it's not clear that overruling them will get us very far. What I have in mind is Citizens United and Shelby County in particular, two decisions widely and justifiably reviled, I think, among liberals. But overruling Citizens United doesn't get you anywhere unless there's a statute that actually limits campaign contributions. And Shelby County too, it's kind of difficult to imagine a scenario in which that case would actually be overruled. You can do it, but what you really need is executive and legislative action on those fronts. But that does sort of lead me to something else, which ties in the theme that Michael kicked off and that everyone has touched on to a degree, which is the uncertainty about the kinds of issues that are going to arise in the next generation. And here's one that I will predict will arise that we haven't mentioned so far, and it is one that cuts across many ideological lines, and that's a trade-off between national security and civil liberties, which is, if anything is likely to be an issue in the next generation, that's it. And that's an issue on which there is, you could the usual lines are don't apply, or at least don't easily apply. And to me, one thing that brings to mind is, and we also haven't touched on today, is the sort of what I think is just the outrageous nature of the Republican obstruction of Judge Garland's nomination. And let me say why I see the connection there. I think it is, another element of the progressive tradition I was mentioning before is, in addition to the things I mentioned, is a belief in things, old-fashioned things like, the scientific method, and facts, and the integrity of ideas, and actually knowing some stuff and trying to do the job right. All of those things that are really under siege now. I mean, a wave of anti-intellectualism coming from certain parts of the political spectrum. And I think what President Obama wanted to do with this nomination is to say, look, I could kind of nominate someone that would put out there for ideological reasons to rally the base. I'm not going to do that. I'm going to put out someone whose professional credentials are completely unimpeachable, even though that's going to get me into some trouble with people on my left, because I want to sort of say, look, I understand it's a divided government, but surely one thing we can agree on is the importance of professionalism. And the fact that that has cut so little weight with one side of the aisle, I think, is a terrible and damaging development. And one thing we should really hope doesn't happen is for the Supreme Court appointment process simply to become a matter of, who can hold out the longest for the judge that they want. And I think, I think the sort of making sure the court is at least a bastion of professionalism and competence is also a value that we should all be concerned about as liberals.
It strikes me talking about when issues might come up to the court in terms of teeing up a case that might reverse something that a more conservative precedent. I'm just wondering if Michael or Ilia think that certain cases that are in the pipeline that have more of a conservative agenda, there'll be pressure to pull back. And I'm thinking of if, affirmative action, there's some cases percolating up challenging Bakke overall at Harvard and University of North Carolina. If we do end up with a strong liberal majority, if that's the case that conservatives might not want to have there, if maybe, frankly, Britter could be strengthened through that kind of case, or conversely, the kind of gun litigation that might be working up below, if that could give a liberal majority a way to undercut Heller in some way. Michael, are there cases that you think that you would want conservatives to start to pull back on, the way that, for example, MALDF and LDF tried to stay away from the court a little bit more?
Right now, it seems as though the cert pipeline is pretty slow and doesn't have a lot in it, so we'd have to be talking somewhat down the road.
Right.
So I don't really know how to answer that question. You mentioned a couple of specific cases. I'm inclined to agree with David about the gun control issue that, I think Heller stood for the proposition that total bans on ownership of guns are unconstitutional. There was only, I think there were only 2 cities in the country that had total bans. I think that the opinion leaves room for lots of regulation, and my guess is that that's going to continue. And I think that it's an outstanding example of where federalism can really work. That there people, the place that guns have in people's lives is very different in a state like Utah than in a city like Chicago. And I don't. It seems to me that Heller left room for that. You also mentioned Bakke. I would, at least from this isn't. I don't represent any group on this, but Bakke represented an absurd compromise, a middle ground position that I think nobody in real life actually holds. If our current doctrine, in Fisher and Fisher before and the Michigan cases, seems to be that universities are able to engage in affirmative action only for this purpose of pedagogical diversity. Well, I think most people who believe in affirmative action think that the reason affirmative action is permissible is because there's a difference between discriminating in favor of subordinated groups for the purpose of redressing historic inequalities. That's the reason affirmative action seems to supporters of it to be right, not pedagogical diversity, which is rather a rather shallow and I think in many cases even cynical a proposition. And of course, people who disagree, who think that affirmative action is unjust, also find the Bakke compromise to be wrong, because if you actually believe that racial discrimination against anyone, majority or minority, is fundamentally wrong, well, the types of programs you see in universities are, obvious workarounds. They're not. It just seems like we're in a world in which people pretend to think that there's strict scrutiny for this, and there isn't. And it makes I don't think it pleases. It's not just that it doesn't please anyone, but I don't think it even makes sense to anyone. So I'm hoping, there are a few things like Bakke and maybe Buckley against Vallejo and some others that have been that we've been saddled with that just don't make any sense from anybody's point of view, and maybe this will be a time when we can see some serious rethinking.
I want to get to Ilia and any cases he wouldn't like to see before a more liberal court. But Steve, for your wish list, would you want more clarity on racial remedies? I mean, because he raises the point about how Bakke obviously was a major compromise, and Justice O'Connor then endorsed it to an extent, but that is an area of the law that's been touchy and difficult, and the court has struggled with. Is that an area, though, that could be solidified more if there were more liberals ready to join together on it?
Well, at the risk of being cynical, I would like more clarity if it's clarified in the direction that I like. But I will just say, in response to a different point that Michael made, and I don't know that you were suggesting this, but Michael, but one way to interpret your comment was that affirmative action could either be justified in terms of its pedagogical advantages or be justified as a remedial measure for groups that have been subordinated for a long period of time. It doesn't seem to me to be an either-or proposition. I think you can believe in both. And I will just say, I don't operate primarily in the academy. I operate in a different institution. But I will say on behalf of the ACLU, over my tenure at the ACLU, the staff of the ACLU has become much more diverse. It's much more diverse today than it was when I joined the organization. And that the conversations that take place within the organization as a result of that increased diversity are very different. And I really do think people bring different perspectives, and that different perspectives inform decision-making. And I don't think that that's a cynical explanation for affirmative action. I think that's a defensible explanation.
Well, the reason it's cynical is that universities do not care a whit about diversity on so many other matters that matter just as much as race. I mean, they are essentially one-party, homogeneous states, and the lack of diversity with respect to political and philosophical and religious opinion is just shocking on American campuses. And when people do not care about that, I think it's cynical I believe it's cynical when they pretend to care about diversity about other things.
Cato has all sorts of diversity. We range from classical liberals to anarcho-capitalists, left libertarians, right libertarians, minarchists, all sorts of people. But I think it's premature for us right now to be talking about the future of racial preferences, given that Fisher is in the offing, and there are 7 justices, so we will get some sort of opinion. Kennedy, presumably the swing vote, famously has never voted to uphold any racial preferences program, but has never closed the door on it. So presumably the question is, how widely is he writing his opinion? As we go further and further, it's taking longer and longer. That indicates to me that maybe Sotomayor is taking more and more time on a scathing dissent, which indicates that maybe the ruling is going to be broader rather than narrow. I don't know, but obviously our response on that will very much depend on what we see in the next 2 weeks in that case. Guns are done. We've seen the Second, Third, Fourth, and now the Ninth Circuits willfully disobey the Constitution. Clearly, there's the right to keep and bear implies a right to carry of some sort of a functional right, but they don't care about that. It's the only fundamental right that works differently or exists, and it's like Schrodinger's right that exists and doesn't exist in different parts of the country. But anyway, that's done. But I am seeing things in the pipeline that are kind of different. The dynamism. The action, and this kind of ties into some things that Rachel said, occupational licensing restrictions, school choice, educational freedom issues that really have the potential to improve the lot and life of the poor and racial minorities and small entrepreneurs. There's no reason that you should have to pass 2,000 hours of training on hairstyling in order to thread eyebrows or braid hair. There's no reason why you have to be stuck in failing schools when there are good schools available if only the law allowed you to access them. And so those kind of challenges, kind of hybrid ones, I am seeing more of, and it is indeed, I'm not involved at the trial level. I don't strategize about what kind of cases to bring. I get involved later at the the amicus and the popularizing kind of stage, but I am seeing more and more dynamism. Again, in the theme that I touched on earlier, micro-regulations are more kind of that affect people's lives directly rather than these big abstract concepts.
I want to actually turn to voting rights, which is something that a couple of the panelists mentioned. But Melissa, first, you jumped in when he was referring to gun rights below in lower courts.
I guess I'm just getting frustrated with gun rights advocates talking about the Second Amendment being the only fundamental right that gets infringed upon in any kind of meaningful way.
No, that's treated differently in different parts of the country, not the same.
But let's be clear. If we can have reasonable restrictions like HB 2 on the right to an abortion, surely we can have reasonable restrictions on the right to bear arms. And so, I mean,
Sure, but you can't say no carrying at all, which is effectively what these laws that have been challenged
and HB 2
do.
effectively says no abortion at all.
I'm not carrying water about abortion. Our abortion jurisprudence poisons our jurisprudence altogether. And Justice Ginsburg herself has said that if Roe v. Wade had allowed the political process to work, maybe we'd end up with some sort of sensible abortion political compromise like in Europe.
Okay, let's. Thank you both. We're going to turn. Anybody want to add anything on that, and then I'll turn to the much easier subject of voting rights. But here we are in the first presidential election year since Shelby County, and we're likely to see obviously a couple issues that come up right from the end of the primary process that we're in now, and the general election. And I just want to get a feel from some of the panelists of what they anticipate in terms of the kinds of cases we'll see, and whether anything can happen judicially related to Shelby County, or if the nature of that ruling is that that's just going to be the kind of thing that if anything changes with the bottom line in Shelby County, it's going to have to come from Congress. Steve?
I don't think we're going to see anything from the court about Shelby County. I think the bottom line will have to come from Congress. I think if we have a Merrick Garland or somebody like a Merrick Garland on the court will have a little more sympathy to challenges to vote suppression measures than it had in the past. Justice Stevens has now sort of publicly acknowledged that his prior vote in the Indiana case was one that he regrets. But I think that the big voting rights case that's going to come up, the big voting rights issue that is ahead of us is the 2020 redistricting. And there is I don't know if it's fair to call a sleeper case, but there's a case that the court just took in the past week from Virginia. It comes up on appeal from a 3-judge court in Virginia, and it has to do with the standards for deciding when something is or is not a majority-minority district in order to protect it from retrogression under Section 5. And how you make that determination is incredibly freighted, in terms of politics, in terms of constitutional law, in terms of racial politics. And I think we ought to be thinking about those cases and the redistricting standards going forward.
Anybody else on voting rights? Okay. The one area, though, that you had mentioned, and it really is completely in the court's bailiwick, is the death penalty. And, when last year, right around this time, we had the Glossop ruling, and it was only Justice Breyer, joined by Justice Ginsburg, who talked about wanting a case that would reverse capital punishment in America. Obviously, Elena Kagan and Sonia Sotomayor might have had a pitch made to them as possible to join that because they did dissent from the Glossop ruling itself out of Oklahoma. And there's one indication of what Michael might talk about in terms of the fractured left on some of these issues. Do the panelists think that we really will, in a short period, see a death penalty case that would tee up capital punishment and would reverse it? Go ahead.
In terms of institutional capacity, this is one of the few things that the Supreme Court could do easily and quickly, and it would just happen, and it would be over. So this is much easier in terms of what courts are able to do. Just to say no to something like that is relatively easy. Now, I'm not necessarily predicting that that'll happen, but it isn't. Most of these other, especially the issues that Rachel are talking about, are deep and intractable and complicated, and you can't just push on a string and have it happen. This is This is an issue of enormous moral and symbolic importance, but there are not that many executions. We could end them tomorrow. The world will be exactly the same. And the Supreme Court could do that. Now, the only obstacle, I think, is the fact that, it's really difficult to say that the Constitution forbids capital punishment, given that it says, and I quote, no person may be deprived of life without due process of law, which certainly implies that they can be deprived of life with due process of law. That's the problem. There aren't any institutional difficulties.
David, what do you think the chances that the court let's just say we get a full contingent sometime in 2017, either right after the lame duck with Merrick Garland approved, or early in 2017 with the president potentially picking up Merrick Garland or somebody else. What are the chances, you think, that by 2018 we'd have a serious case up there and potentially a ruling that would overturn capital punishment?
Well, Joan, that trajectory of these things, and we've seen it with lots of issues, most recently with same-sex marriage, the trajectory is something starts out as being more or less unthinkable, and then you see society moving. And when things have gotten to the point where the court thinks, basically except for a few places in the country, we're already there, that's when the court steps in and says, we're going to take it the rest of the way. We've seen that pattern over and over again with the Supreme Court. I think it's the way it operates. I think it's an appropriate way for the Supreme Court to operate. We really have reached a national consensus on this issue. And that's what I would expect. I would expect to see a narrowing of the circumstance in which the death penalty is allowed by the Supreme Court, and then at some point for the court to come along and say, it really, as Michael said, this is such a marginal part of the criminal justice system now. We're just gonna end it. And I would with Steve, I would expect that to happen. I don't think they will do it immediately. I don't think they should, possibly, I don't know if I want to say should. I understand why they would not want to do it immediately. But I think barring something really shocking and unexpected, I would expect to see that happen sometime in the reasonably near future.
Talking about public attitudes that might move people, move the public and then eventually move the court, I want to, before we take questions in a few minutes, just touch on two more issues. And one is abortion and the undue burden standard. That's one where public opinion since 1973 has remained pretty divided. Do any of the panelists have any feeling about where the court, first of all, any predictions of what will happen in whole women's health, given that is one where we could potentially deadlock? And then I'm going to go back to the gay rights issue and end up on transgender issues, just because those certainly are percolating up here sooner rather than later. But reproductive rights.
Melissa would be the one, I think. She just did the brief.
What do you think, Melissa?
I don't want to hazard a guess about Hellerstedt. I'm already a little nervous about what might happen in Hellerstedt, but I think going forward, what would be really interesting to see is to sort of expand kind of our concept of what reproductive rights and justice might mean. I would, like, if we had our druthers, like if I'm in Steve's world and I'm thinking about what I might like to see revisited, I would love to see Harris versus McRae revisited. I think that is the most undersold repro case in the canon. Like the idea that the right to privacy includes the right to an abortion, but only if you can privately fund it yourself, has real consequences in the lives of lots of women, and I think that's something that should be revisited. I don't know if it would be revisited in a more progressive court. I think it does raise questions of access. I think if the right is reframed as one of women's equality and sex discrimination, then maybe it's more likely that would come up. But there are just so many reproductive rights issues right now that are percolating, not just in Texas, but throughout the South and other parts of the South, not just related to abortion in clinics, self-induced abortion, the whole question of fetal homicide. All of this, I think, raises important questions that I think in time will percolate to the court. But I agree with David. This is a court who has an informal symbol of a turtle, and I think rightly so. Like, it makes incremental steps. It makes steps that really just herd the recalcitrant into line over time. And we saw this with Obergefell. We we didn't get a decision on same-sex marriage in 2013 because it seemed like there was no national consensus on the issue. And then all of a sudden, lower courts started using Windsor to strike down their state laws prohibiting same-sex marriage. And lo and behold, 2 years later, you have Obergefell. The same thing happened in the 1960s with Loving versus Virginia, right? The year after Brown, there was a case called Name versus Name that sought to strike down anti-miscegenation laws. It was punted on procedural grounds, and then 13 years later, after you have all of these anti-miscegenation laws repealed through the political process, you have a decision like Loving versus Virginia. So there's what I would love to see happen, and then there's what is realistically, I imagine, would happen. And I think there needs to be a lot of political change. I think a lot of things have happened in sort of being more public about what reproductive rights means and what it looks like in everyone's lives. I think the brief that was filed before the court by women lawyers talking about what the right to an abortion meant for them in terms of their professional lives was really important, and I'd like to see more advocacy like that, the kind of work that we saw in the LGBT rights struggle, also to see that happen in the reproductive rights struggle.
David, you have one more thing before
Just
we
one quick thing on that. I agree with Melissa that it's a bad thing that Harris against McRae has kind of dropped out of the picture, and that even progressive politicians will say, well, of course, we're not pushing for funding of abortions. But I particularly want to say something to people, including people in the progressive movement, who are troubled by abortion and maybe even find abortion morally wrong. And there are progressives who think that. There's a sort of a Catholic social democracy tradition that we should not lose sight of, that's done many good things, that is opposed to abortion, also opposed to capital punishment for similar reasons. But I think people in that world really ought to be troubled by Harris against McRae. And their view ought to be, look, this is a difficult, divisive, contentious moral issue. I speak for people like that, of whom I'm not one. I'm opposed to abortion, other people are not. But gee whiz, here is a way we should not compromise this issue. We should not compromise it on the backs of the worst off people in society. And say the way we're going to solve this issue is, if you can afford an abortion, you'll get one, because we're afraid of losing your votes. But if you can't afford an abortion, then okay, that's where we'll compromise. That's how we'll solve this issue. I just don't think that's a good way for society or for liberals or for a court to allow things to develop. John Hart Ely, my teacher, was opposed to Roe against Wade. He thought Roe against Wade was wrong, and he thought Harris against McRae was wrong for essentially these reasons. And that's not my position, but I think that's a position that ought to be out there in the conversation.
Can I say something on that? Of course. I'd like to get rid of the undue burden standard simply because I don't know what it means. And it basically has come to mean whatever Justice Kennedy thinks it means. That's not a way to do law. Similarly, as a lawyer, I can't tell you when rights attach. Whether it's conception, birth plus 30 days, money-back guarantee, I love Peter Singer, quickening, ensoulment, first, these are not legal questions. And I think it would be an improvement if we got rid of undue burden and went back to an actually enforced Roe v. Wade standard, where the presumption is first trimester or first 12 weeks, as in Europe, it's legal, last trimester not, sliding scale in between. Something that would be more of a political compromise. I don't know if a court can fashion that, but really, I think what I'm hoping to see from this case, and I'm happy to predict that it'll be 5-3 for the challengers. I think Kennedy will probably side with the liberals on this, but who knows? But I would like to see some language about whether we can take stated government motivations for legislation at face value. Because something like that this is just pretextual, that they're saying they're doing this for health and safety, but they're really not. That sort of language could be used to challenge a whole other noxious government legislation across the board. So that's what I'm looking for from this case.
Great, and we've got
May I just jump in here? I think this is one of those places where progressives are going to have to decide whether they're serious about their adherence to basic democratic norms, or whether they're more committed to particular controversial positions that they feel very strongly about. Because Roe versus Wade has been with us since the early 70s. The public opinion it goes a little bit up and it goes a little bit down, but it's been extremely stable. And, roughly a quarter to a third of the American public is seriously pro-life. about a quarter to a third of the American public is seriously pro-choice, and about a third of the American public is very conflicted, does not believe in either of those positions taken to their extremes, look for intermediate positions, think that context matters, and this has been the case for a very long time, and it is not a generational thing either. If you compare the opinion polling about abortion to opinion polling about same-sex issues, it was obvious what the future was going to bring, because you look at the oldest cohort still has lots of problems with it. The youngest cohort, even strongly conservative evangelical young people, do not have a problem with same-sex relationships. You look at abortion, and it is not that way at all. In fact, the younger cohorts tend right now to be slightly more pro-life than I think it's our age cohort is the most strongly pro-choice of any of the age cohorts right now. So it's not going to go away. People really, and on the pro-life side, this is a deeply held moral conviction, and it has to do with whether you think that an unborn child is a life or not. I mean, and that's not going to. It's not something about money, and it's not something about prejudice. It has the idea that it's a war on women, I think, is quite unfounded. In fact, most polling, the polling on this is not quite consistent, but most of the time, women are slightly more pro-life than men are. It's not an anti-woman thing. It has to do with the moral conviction about the status of babies in the womb. And I think that if the court wants to take these steps to move into a completely pro-choice direction, they're not going to be following the will of the American people, which is somewhere in a muddled middle. I really dislike the undue burden standard too. I don't know where it came from. I don't know what it means. I agree with all the criticisms of it, but maybe that's its virtue, is just what a muddle it is, because maybe that's where the American people are.
Thanks. We're going to pivot to another issue, but Melissa, you want to respond to that at all?
I would like to push back on the idea that this is not about a war on women, that it is about babies. And I would point to my colleague and co-author Kristen Luker's work, the Pulitzer Prize-winning nominated book, Abortion and the Politics of Motherhood. This is fundamentally a debate about the role that women will play in public life, whether they will be mothers consigned to motherhood or whether they'll be given the opportunity to make other choices. So yes, I do think the whole question of when life begins is an important part of this issue, but we should not overlook the fact that this is also an issue that is essentially about the role women are going to play in our society.
Actually, I love her book, and one of the things I took from the book is the degree to which the argument about abortion is not exclusively, but very heavily an argument between women, that the most passionate voices on both sides of the issue are women. Men do have opinions, but to some extent they stand aside, and women are arguing about this. I mean, that's what her book says, right? The leading activists on both sides speak to it as women from a woman's point of view.
It is very definitely a debate between women, but it is about two different views of what a woman's role should be, whether it should be a more traditional role of motherhood and wifehood, or a role where those things might be combined with a life in the public sphere as well. And in that sense, Steve is exactly right. It is an issue of women's equality that perhaps should be more expansively framed beyond the scope of the right of privacy.
Thank you. You know, We have gotten a lot of questions already, so I think I'm going to quickly start going to the audience and just to see what people want to talk about, and maybe some of the transgender LGBT issues will emerge in the questions too, and we can circle back to that. But let me just start with the first of many that we've gotten, and Ilia, I'll address this to you first. In a court that moves to the left, the audience member says, what do you see of Chief Justice Roberts' role? Will he try to join the majority and move it a little bit to the right, or will he end up being a dissenter? I think this is a great question because when he came on in 2005, he had a court ready-made for him, of course, and it has been easy to be in the majority. It has been easy to have the assignment power, and it might not be at his fingertips going forward in 2017. How do you anticipate the role he might play?
I think he will, it's his goal to be as unanimous as possible. It's always been that. He hasn't obviously always achieved that. But this term, I guess we're seeing more of that, although we saw plenty of unanimous opinions with strident concurrences that were dissents in all but name, I think 2 or 3 terms ago as well. But I think he still will strive, and he still will see himself as the Chief Justice and kind of the keeper of the court's integrity and legacy, and his own legacy as well. So I think there will be lots of times, cases where, if indeed there are 5 left-wing votes, that he will join the majority and try to narrow the majority or plurality opinion in some way so as to control the shape that the court goes. That's perhaps what happened in King v. Burwell, for example, where there's speculation. Did Kennedy defect already because it's a statutory interpretation case, and then Roberts went over to control that ruling? But I think you'll see that sort of dynamic quite a bit.
Does anybody want to add anything before we move on?
I think there's a reasonable probability that the court is not going to be in 2 camps, that it's going to be in 3 camps, that there will be some conservative justices, there are going to be some seriously progressive justices, and that John Roberts and, I don't know exactly who this would be, but I would guess Stephen Breyer, possibly Elena Kagan, will be, and Merrick Garland, if he is confirmed, as I would guess he will be in the lame duck session, would form a middle. And it's hard to know how that kind of dynamic works out, but it might not be bad.
Can I just say one quick thing?
Of course, yeah.
Which is that Justice Breyer made a comment somewhat along the lines of Ilia's comment recently when asked about the 8-person court, and he said, well, it's not as bad as people think because we decide an enormous number of cases either by supermajorities or unanimously. That's true statistically, it's true quantitatively, it's just not true qualitatively, in the sense that almost every important case that the court decides is a closely divided case, unless the court decides to punt in some ways, which is what they're doing this year. And I don't know if the court divides into two groups or 3 groups, but I don't think any Chief Justice can allow himself, and I don't think this Chief Justice will allow himself to become a permanent dissenter. That's just not a role that the Chief can play. So he's going to find some way, I think, to be in the majority in a large number of cases.
Thanks. Okay, this is from another member of the audience. Admittedly, this is less sexy than some issues mentioned, but should we expect any loosening of standing doctrine and greater opening of courthouse doors?
Oh, good. I was hearing an ERISA question.
Well, I actually think this is a great question, especially for someone like Rachel and Steve, about just access to courts, issues that we've had in terms of standing. Anything you want to address there, Rachel or Steve?
Yes, I think if there is a possibility that the court will relax some of its standing decisions, which have been pretty restrictive in recent years. And if you look at Judge Garland's decisions, which I have done in the context of his nomination, he's actually pretty sympathetic on access to justice issues. So I think the addition of his vote would sort of shift the dynamic of the court on those questions.
Script a little bit, because I think while all of the formal doctrines of standing and so on are important, right now, if you're a poor person in America, you can't get a lawyer for many, many purposes. We've restricted Legal Services Corporation's ability to bring class actions. We now are asking poor people to use self-help websites to handle their legal needs. We're treating their legal needs as ordinary and commoditizable, and we're ignoring the very complex structural barriers to equality and participation that exist. So to stop at the point of the formal doctrine and not acknowledge all of the structural stratification that makes access to justice meaningless for many, many people in America is, I think, a disservice. The other thing that I would say is, for most people, the federal courts are irrelevant. It's the state courts where they're caught up, whether it's with a misdemeanor or a criminal allegation, or they are really facing state courts that have been gutted by budget cuts, which cannot serve civil justice cases in a timely way. As consumers, they face arbitration clauses that prevent them from going to court altogether, which they sign, quote, voluntarily at the end of a long series of terms and conditions. And so to ignore those structural problems and focus solely on things like standing doctrine is, to me, to some degree, miss the point, which is when you revive the people and their ability to seek justice, they will demand that those doctrines change. They will not wait passively for that to happen. Right now, I think they're forced to do that. And I did want to circle back to LGBT because it is related. Believe it or not, it's an interesting seg. But I think it is probably the most significant cause lawyering civil rights victory in recent memory, and it didn't happen by sole reliance on the courts. Let's be honest. People went to researchers. I was the dean. I saw the Williams Institute at UCLA School of Law work through this campaign, and it was a campaign. And it began with data to counter negative stereotypes. It began also with making sure those data were available to advocates around the country. It focused on progressive localism, places where change could happen, places of influence which could make change happen in other places. They didn't forget the states. They cared about the federal, but they knew also that if there wasn't a mobilization of public opinion, the courts would not change. So when you say the courts wait for everybody else to get in line and then just close the gap, that means that's part of your strategic thinking about how to make change happen. So in some ways, the court comes last after laying this foundation. And I know that a lot of other groups, including Latinos, are looking to what LGBT people did to think about how to improve their conditions. And so it's a tremendous victory, and it's one with a lot of lessons about how you mobilize for change, instead of just focusing on questions of formal doctrine, which I don't think are enough.
I'm gonna move to two specifics that folks have asked about in terms of reversals. What are the chances that a majority liberal court strikes down partisan gerrymandering? And just to get it laid out there, what do you think will really happen with Citizens United? David?
On the gerrymandering question, I think that is, I do think that's a possibility. I mean, who knows? We're all speculating, but I think what's happened in areas like gerrymandering, two things have happened. One is the ability to gerrymander, as we know, has become much more sophisticated, much more subtle than it was when the court first engaged with these issues almost a generation ago. So it now is a greater threat than it was, and there's reason for the court to try to figure out some way to deal with it. The other thing we've seen, and this is another really troubling trend that's going on out there, in any functioning organization of any kind, and especially in a big, diverse society, there has to be some kind of agreement across the board on the basic rules of the game. Otherwise, things collapse. And one of the rules of the game, I would have thought, used to be, people get to vote, and their votes ought to count. And of course, they're kind of, I'm from Chicago early, often, blah, blah, blah. I mean, there's the people, the shenanigans, electoral shenanigans are a familiar thing. But a baseline agreement that you don't try to disenfranchise large chunks of people, and in instances in the past where they have been disenfranchised, were a disgrace, and we've tried to end that. And there's an erosion of that, and I would expect to see a court react to that and step much more vigorously into this area with voter ID laws and gerrymandering than it did a while ago. And someone like Justice Stevens, who I think really came from a different world, and Judge Posner, were surprised by the extent to which things have really moved in a negative direction. I would expect this court to try to push back against that.
All right, I don't want to give you the shakes like you had after the New Hampshire primary, but somebody really wants to know, what could we expect from a President Trump in terms of judicial nominees? Now, I think everybody knows we at least had those 11 that were put out there, so.
Tremendous list, great list. Let me tell you, best list. Seriously, the list is great. I just don't know how much I can trust it, you know? I liken it this way. If on a scale of 1 to 10, from my perspective, Hillary's a 3 with a range of 1 to 5. Trump is a 7 with the range of 0 to 10 million, right? So, or negative 10 million to positive 10 million. So it's just a wild card. Judges are, judicial appointments are the least reason to vote against Trump from my perspective, or maybe the best reason to vote for him. It's not enough for me, but it is for some legal, conservative, maybe even libertarian elites, because it's such an important issue and given the historic vacancy now on the Supreme Court. But you know, it just depends. Will he be a deal maker and say, look, I'll give you this judge if you give me the wall or whatever? Will he be like, well, this is not important to me. I want to deal with my, you know, my priorities, and I'll throw a bone to the, you know, the movement conservatives by giving them judges because I don't really care. Or will it be, hey, I'm starting to understand how these judges work. Wait, these conservatives are telling me to appoint judges that are against eminent domain and for First Amendment rights and all these other things, that against executive power abuses? No. I want docile judges that will approve whatever I do. And so, again, these are sort of the things to consider when you're thinking about what kind of judges Trump will appoint.
Anybody want to add to that? Okay.
I just have a question for the panelists, because as I've heard, you know, about this notion of people asking, aren't 8 justices really enough? It seemed to me an interesting historical inversion of FDR and court packing, but to dilute the court in the opposite direction. And I just wondered if people had any thoughts about the historical resonances with other kind of adversarial relationships. This case, it's between the legislative branch and the judiciary, and in others, it's been the executive branch and the judiciary. But do people see any parallels?
I can say something about that. I actually think it's, I mean, you know, I think as they've been saying, we can get by with 8. You know, I don't think the shorthandedness of the court is intrinsically a huge problem. Obviously, over time, they have to be able to make decisions. I think you want to say, well, why is it shorthanded? Now, if it was shorthanded because there was a debate going on, either within the executive branch or between the executive branch and Congress, over whether a particular person should be on the court, and there's a good faith debate and the sides had differing views, and that I think is that's a debate that ought to be had. And if the court is going to be shorthanded for a time while people work out that very important question, I think that's a cost we should be willing to bear. What's troubling about this is that's not the debate at all. No one questions the qualifications of this nominee. You don't see, and maybe there are 1 or 2, but no Republican really thinks, no, this is not a sort of nominee that's acceptable. What they think is, we don't want a Democrat filling this seat. And I think that's a recipe for disaster. Because, and the president has said this, you know, if the Republicans succeed in holding that seat open and a Republican president fills it, when the shoe is on the other foot and the Democrats are in that position, they're not going to lie down. They're not going to say, oh, okay, fine, you blocked Merrick Garland, we'll let you have your appointment. They're going to do the same thing, and that really does threaten things. So, you know, we can live with that. What we can't live with is a party taking the position that we are simply, because we control the Senate, we are simply not allowing you to fill that seat, no matter whom you fill it with. I think that's the problem.
Okay, another question. Do you believe the right to counsel, free of charge, if you cannot afford one, will be given teeth by the Supreme Court in the near future? Steve?
No. With 2 caveats. I think the problem is primarily a funding issue. And I don't think the Supreme Court is going to wade into that fight, and it's primarily a funding issue at the state level, not at the federal level. I do think that what we might see is an expansion of Gideon to other contexts beyond the criminal context. Now, you know, Gideon has been more right in theory than in fact, for all the reasons that Rachel was saying, but we're already starting to see movement in the immigration immigration context. And I would not be surprised to see the Supreme Court agree that minors have a right to counsel at immigration proceedings. People who are mentally incompetent have a right, and ultimately extend full Gideon rights to the immigration context for anybody facing deportation who cannot otherwise afford a lawyer because of the consequences of a deportation decision, even though it's nominally labeled civil.
This one comes from someone who clearly watches a lot of oral arguments. Regarding the proposal that Congress, not the Supreme Court, should be addressing all policy issues, and the questioner notes that Don Verrilli said to Scalia, this Congress? If Congress remains gridlocked, shouldn't someone be addressing policy?
I'll just say that gridlock is a feature of our system, not a bug. If the American people are so divided that they go back and forth, different elections are completely split. Our system is designed to produce legislation, or they're not supposed to have governance through administrative agencies so much through the executive, but you only have empowered, long-standing majorities that are meant to change policy, and so. I don't know. Maybe the Trump earthquake reshifts, jumbles up all of our politics. If he's elected, then maybe we'll see bipartisanship in Congress against him. That would be a great check, finally, on the executive. But,
I just wanted to say that I think there are areas where public opinion is pretty consistent, and we're still gridlocked. And people attribute that to things like how we set the rules of the game.
That's why we should have more federalism, so the decision makers are as local as possible. In a large, diverse, pluralistic society, there's no reason why all of these decisions should be taken in Washington.
Well, just to go back, I was thinking about the safe seats problem, that many people feel that the reason we have gridlock is not because the American people in some monolithic sense are divided, but because we've created intensification and polarization through the way that we assigned the representation of districts. And so that would suggest that it's not just a natural problem that we can't change, but it's an artificial problem of our own making that we could address by recalibrating the rules of representation.
Somewhat, but you're not going to get rid of it all simply because Democratic voters tend to be much more concentrated. So even if you change certain rules of districting, I think you're going to be left with that situation. And of course, the Senate is not meant to be a purely majoritarian body anyway. It's so historically so. Thank you.
We've got time for two quick ones left, and one is kind of a little more contemporary regarding the safe spaces movement. And Melissa, I direct it to you first. Regarding safe spaces on college campuses and public universities, would the court or you distinguish between mandating those spaces and allowing them? And the question arises from a free speech perspective. And how would what kind of advocacy could you see emerging in that way regarding the safe spaces on college campuses? Question.
I would actually like to pass on this question just because in my official capacity I am dealing with this right now.
Okay.
Michael, though, I think probably has some thoughts.
Nice handoff there. Okay.
I do.
Yeah.
It depends on what we mean by safe spaces, because I believe that students on campus should be able to have voluntary associations, and that they should be able to meet among themselves without having outsiders come in and disrupt their meetings. That would to hold that would require reversing Christian Legal Society against Martinez, I think one of the most anti-civil libertarian decisions of the modern Supreme Court, which held that public universities can require groups to have leadership from people who don't share their ideals. Now, if safe spaces means that large portions of a campus are reserved for particular groups of people and others can't go there, I think that's completely inconsistent with the idea of both of freedom of speech and also the very notion of what a university is like. So I think people should be able to meet together on a voluntary basis, but I don't think universities should be shutting off spaces from making them free speech forbidden zones, or some universities have little free speech zones, which are a tiny portion of the campus, and freedom of speech isn't recognized elsewhere. I think that's a catastrophe.
Well, Christian Legal Society, though, to be fair, didn't say that you couldn't organize voluntarily. It said you can't organize voluntarily with state funds and then discriminate against people who are within the community who want to be participating in your organization. So if you wanted to be exclusionary of a select group of people within that organization that's supported by state funds.
That's what safe spaces are. They are exclusionary. And what the case held was a student group, a Bible study group, could not meet on campus in a room unless it was willing to have non-Christians, atheists, people who don't agree with them come in and disrupt them. That's the holding.
But that was because the notion was that state taxpayer dollars couldn't fund an organization that categorically discriminated against certain members of that community who would be...
That is to say they discriminate against people who don't share their view. That's every safe space is going to be like that, right? Anytime any group wants to have a safe space where they can meet together without having other people coming in and bombarding them, they're excluding people who don't share whatever it is, whatever the particular set of beliefs is that is the reason for their meeting together.
We shouldn't have so much government involvement in state funding of so many things. You wouldn't create these clashes.
Well, the state funding we're talking about is access to space, to places on campus.
There was a state-funded space with people paying to it, right? So there's a combination of state funds, but the notion was it was public. So if you had a public space, you couldn't categorically exclude some people from participation in an organization that received public support. Nobody said they couldn't organize with their private resources on a purely voluntary basis. It had to do with the public element of supporting that discriminatory set of access, provisions about access.
What this means is a rape survival group on campus can't meet together and exclude men.
That's correct. And by the way, men can be victims of rape.
Wow.
Okay, I'm going to cut that up there. Thank you.
But what
Michael, thanks a lot.
That does mean there cannot be any safe spaces.
Okay, thank you both. We are now out of time, and I just want to say one thing before I thank the panelists. I forgot to tell you to turn off your cell phones. Obviously you did, and that this is eligible for CLE credits, so make sure you fill out the form. Thank you all for such a vigorous conversation. Really appreciate it. Thank you. That's great.